The South African Human Rights Commission currently issuing out the findings of their report after the tragic events that unfolded at Enyobeni Tavern. Let's listen in.
It would never be in the public interest to continue issuing liquor licenses at a ratio of 1 inspector per 470 license holders, as would be physically impossible to oversee these licenses. It would appear is known to nefarious actors and may contribute to continuous flouting of liquor laws as found in the Enyobeni Tavern tragedy. 9.5, the leisure and clear inability of Eastern Cape Liquor Board to prioritize the speed up of a designation of its inspectors as peace officers under Section 334 of the Criminal Procedure Act further undermined its ability to effectively enforce liquor regulations, thereby perpetuating a regulatory environment susceptible to exploitation and non-compliance. The Commission notes that a request was made to the Minister of Justice and Constitutional Development and finds that the delay in declaring these inspectors as peace officers contributed to a toothless environment not only known to the ECLB but also to the industry at large. 9.6, the Commission further finds that the absence of a robust process for the committee consultation where ECLB would provide expert and informed advice to communities in anticipation of possibly housing tavern within the vicinity violated the principles of participation and transparency, essential components of the right to dignity and the right to safety and health environment. 9.7, this failure is particularly egregious considering the effective community engagement is crucial for assessing the potential impact of legal establishments on vulnerable communities, ensuring their voices are heard. The fact that ECLB is only concerned with receiving proof of service and consultation report without inquiring what community was in fact advised is concerning. It appears to be purely administrative process of rubber stamping any application which is placed on their table without determining whether the committee provided informed consent. 9.8, furthermore, the ECLB issuance of licenses in non-compliant areas disregarded the zoning regulations, thereby jeopardizing public safety and exacerbating the risk of harm, directly infringing upon the right to life, the right to health, as well as the health environment. 9.9, the Commission also finds that the weak legislative framework and the nominal fines imposed on liquor outlet owners for violation fail to serve as an effective deterrent, further exacerbating the risk of harm and contributing to violation of human rights. 9.10, in light of these systemic failures, the ECLB conduct has undermined the fundamental rights to dignity, safety and health environment, health and children's rights, highlighting a clear breach of its duty to respect, protect, promote, and fulfill rights as mandated by Section 7, subsection 2 of the Bill of Rights of South Africa. The Buffalo City Metropolitan Municipality. The Commission finds that the Buffalo City Metropolitan Municipality failed to fulfill its obligations in ensuring the protection of fundamental human rights, particularly in relation to zoning regulations, monitoring of liquor license application, and establishment of the local drug action committee. 9.12, despite submissions affirming that the BCMM Council received the report of the Ward Committee and acknowledging BCMM's obligation to monitor new liquor license applications published in the Gazette notices, the Commission finds it impossible that the BCMM was unaware of taverns concerning operations. The revelation that the Enyobeni Tavern operated without proper zoning as a business establishment underscores BCMM's failure to enforce zoning laws, building regulations, directly infringing upon the right to a safe and healthy environment as safeguarded by international human rights instrument 9.13. Additionally, vague response regarding the oversight of taverns operation and its failure to proactively engage in compliance monitoring of liquor license application demonstrate a lack of accountability and transparency, further compromising community safety and well-being. 9.14, BCMM's inability to establish the local drug action committee, despite legislative requirements and recognition of socio-economic challenges, reflects a systemic failure to address substance abuse issues comprehensively, thereby infringing upon the right to health, exacerbating social vulnerabilities, particularly among children and youth. The Commission concludes that BCMM's conduct regarding the Enyobeni tragedy reveals significant shortcomings in regulatory oversight and responsiveness to community concerns, resulting in violation of the rights to a safe and healthy environment, health and children's rights as enshrined in the international human rights laws and domestic legislation. The South African Police Services SAHRC officials from Scenery Park Police Station confirmed their awareness of complaints against the Enyobeni Tavern dating as far back as December 2021, with subsequent complaints being lodged with SAHRC officials over the years. The Commission finds that SAHRC failed to fulfill its duty to protect public safety and uphold relevant regulations, thereby contributing to a range of human rights violations in relation to Enyobeni tragedy. SAHRC's inadequate response to reports of underage drinking and other violations at the tavern raises concerns about the thoroughness and the effectiveness of its investigations, directly impacting the right to a safe and healthy environment, particularly for vulnerable individuals such as children. Despite receiving complaints regarding noise and public drinking near the tavern, SAHRC's reactive approach focused on a dialogue rather than strict enforcement of relevant laws and regulations, indicating a lack of assertiveness in addressing potential violations and protecting community well-being. Moreover, SAHRC officials acknowledged Mrs. Ndevu's uncooperative demeanor when addressing the complaints with her. SAHRC officials also observed untoward behavior of patrons, non-compliance on part of the Enyobeni Tavern, yet failed to effectively investigate and maintain public order, whether on their own accord or through that of collaborating with Eastern Cape Local Board and the BCMM. In light of these findings, the Commission concludes that SAHRC's conduct in relation to Enyobeni Tavern tragedy resulted in violation of rights to a safe, healthy environment, freedom and security of person, and effective remedies as enshrined in the International Human Rights Instrument and domestic legislation. Department of Health, starting at 9.23 until 9.27, the Commission finds that the Department of Health's handling of the Enyobeni Tavern tragedy has resulted in violation of the right to dignity of the victims' families. 9.24, The initial reports suggesting menthol poisoning as the cause of death later refuted, followed by the emergence of suffocation due to overcrowding as the purported cause, created confusion and distress among the affected families. 9.25, the lack of clarity and consistency in the information provided exacerbated their trauma and denied them the dignity of knowing the truth about circumstances of their loved one's death. 9.26, furthermore, the obstacles faced by family members in assessing relevant information and the department's explanation citing confidentiality and legal constraints raise questions about transparency and accountability in the investigation process, further eroding the family sense of dignity and respect. 9.27, the repeated postponement of formal inquest proceedings to investigate the deaths prolonged the agony and uncertainty for the bereaved families, denying them closure and perpetuating their suffering. In failing to provide timely and transparent resolution of the matter, the Department of Health has failed to uphold the dignity of victims and families, thereby violating their fundamental human rights. 9.28, the National Department of Social Development, which is NDSD, and the National Department of Trade and Industry, which are also referred to as NDTI. The Commission finds that the NDTI and the Department of Social Development have failed to fulfill their obligations under Section 7, subsection 2 of the Constitution, as well as their obligation under international treaties, such as the SAHRC, which is the Convention on the Rights of Children, and ECLB, which is African Charter on Rights and Welfare of Children. 9.29, Section 7.2 of the Constitution imposes a positive obligation on the state to take reasonable legislative and other measures within its available resources to achieve the progressive realization of socio-economic rights. Similarly, the SAHRC and the ACRWC require state parties to take all appropriate measures, including legislative steps to protect children from the illicit use of psychotropic substances, which includes alcohol. 9.30, despite these obligations, the NDTI and the NDSD have failed to prioritize the improving legislation that could have protected the lives of the Enyobeni Tavern tragedy and others affected by alcohol-related harm. 9.31, the final national liquor policy issued in 2016 made clear recommendations for comprehensive amendments to the National Liquor Act to address the challenges associated with alcohol abuse, including advertising restrictions and stricter regulations on the sale and supply of alcohol to minors. 9.32. However, the bills such as the Liquor Amendment Bill of 2016 and the Control Marketing of Alcoholic Beverages Bill of 2013 have seen little to no progress in legislative process, despite their potential to significantly reduce alcohol consumption and regulate alcohol marketing. 9.33. Furthermore, international frameworks such as the World Health Organization Global Strategy to reduce harmful alcohol use and the World Health Organization African Regional Strategy for Alcohol Control emphasize the importance of protecting children from alcohol harmful effects through measures such as marketing restriction and age restrictions on alcohol sales. 9.34, the failure of NDTI and NDSD to prioritize And further, these measures demonstrate a clear disregard for their obligations to protect children's rights and protect public health and safety. 9.35. Therefore, their inaction constitute a violation of Section 7, subsection 2 of the Constitution, as well as the obligation under the SAHRC and the ECLB to protect children from the harms of alcohol abuse and promote public health and safety. Now we get to our recommendations as the Commission at 10.1, which is the moratorium on issuing on-site licenses for the Eastern Cape Liquor Board. 10.1.1, the Eastern Cape Liquor Board, with the cooperation of GEDEAT and other stakeholders, to consider an immediate moratorium on issue of new on-site liquor licenses until sufficient capacity is appointed to effectively monitor compliance with existing regulations. 10.1.2, this pause will allow Eastern Cape Liquor Board to address the current deficiencies in enforcement and ensure that future licenses are granted responsibly. And 10.1.3, the Commission acknowledges that this recommendation may impact Section 22, rights of prospective business owners and the dignity of rights of alcohol consumers, as often emphasized by liquor industry. However, the Commission firmly asserts that any restriction on the liquor industry's right to trade or the dignity of alcohol users is justifiable under Section 36, analysis and rationality test. Considering the public interest, principles of Ubuntu, and common sense, the state is compelled to take urgent action to address the pervasive issue of alcohol misuse and abuse in South Africa's socio-economic landscape, and to ensure that children's rights are protected and promoted. The peace officer status, the Eastern Cape Liquor Board must expedite efforts to secure approval from the Minister of Justice and Constitutional Development to designate the ECLB inspectors as peace officers under Section 334 of the Criminal Procedure Act as amended. 10.2.2, this designation will empower the Eastern Cape Liquor Board inspectors to enforce compliance with liquor laws more effectively and enhance their ability to address violation. 10.3, alignment with new legislation and policies. The Eastern Cape Liquor Board should ensure that any new legislation and regulations align with the provisions outlined in the Draft Liquor Amendment Bill of 2018 and the final National Liquor Policy of 2016. This alignment should support but not be limited to, firstly, 10.3.2.1, and I'll go as far as 5, restricting advertising of alcohol on print media, television, radio, billboards, and all other public areas except at the site of sale. 10.3.2.2, prohibiting the location of liquor outlets within 500 meters of schools, residential areas, and places of worship and recreational centers. 10.3.2.3, increasing legal drinking age from 18 to 21 years of age. 10.3.2.4, regulating specific trading days and hours for alcohol to be distributed and manufactured. 10.3.2.5, placing liability on alcohol retailers and manufacturers for harm related to the contravention of regulations. 10.3.3, the Commission again underscores that the justifications behind these potential limitations are reasonable and justifiable in an open democracy, and the research behind these recommendations are already included in the state's own policy consideration. Enhanced community engagement, 10.4.1, the ECLB must prioritize meaningful engagement with affected communities during the liquor license process and renewal by way of its physical presence.
All right, those are live visuals from the East London for you, the South African Human Rights Commission in the Eastern Cape, giving their own findings following their investigation into the report, looking into what took place at Enyobeni Tavern. And I suppose what's most important to come out of that is this bombshell. Part of the recommendations, I beg your pardon, is that they're calling for a moratorium on the issuing out of licenses for on-site consumption from the Eastern Cape Liquor Board until there is sufficient capacity to ensure that there is an adherence to the laws. In other words, no new licenses, says the Commission, should be issued out until the Eastern Cape Liquor Board is able to get its house in order. It's probably breaking news. Another recommendation, moving the legal age for alcohol consumption from 18 to 21, restricting the hours in which you can sell alcohol. This particular commission being scathing against the Buffalo City Municipality, of course, where Scenery Park is, as well as SAPS officials who had been told about what's taken place there, but seemingly focused on dialogue instead of law enforcement. That's a direct quote. I imagine there's going to be a lot to come out of this particular report itself and the reaction, and we're certainly watching it for you as it unfolds.